Our next session is on general sessions, and we have Jane Morris with us who will be presenting. She is the managing attorney at Knoxville's Legal Aid of East Tennessee office. She began working with Legal Aid of East Tennessee in 2009. Her casework focuses on consumer and debtor creditor issues, and family law. She has a BA from the University of Notre Dame, and then she has a master's degree in social anthropology from the University of Texas at Austin. She attended Cornell Law School. She is licensed in Pennsylvania, Iowa, and Tennessee. So please help me welcome Ms. Morris. Thank you.
Everybody get a handout? Okay, good. Okay, we're going to talk about general sessions practices and procedures. I'm going to talk primarily about civil sessions like detainer court and sort of debtor-creditor issues. One thing when you're talking about general sessions court that you have to remember is it's not a court of general jurisdiction, it's a court of limited jurisdiction. And what that means is that there's no common law that applies in general sessions. If you want a general sessions judge to do something for you, you've got to find somewhere in a statute or a private act the authority for the general sessions judge to do that. The statute that primarily applies to general sessions is, I have it listed there, 1615, and it lays out everything that the general sessions court is going to do. In addition to that, there are these private acts that apply to each and every county. And one of the funny things about the private acts are that they're not available in the statute book, you know, the code. You have to actually go someplace else to find them. And I have an online site where you can find those. You know, Tennessee is the third state that I've been licensed in. And to me, there's a lot of things that are weird about practicing in Tennessee, like your non-suit rules and the fact that you have a chancery court. But the weirdest thing to me is that you go to general sessions in one county and they do completely different things than general sessions in another county. And it's not like that in other states. You might not know that if you only practice here, but that's really weird to me. And the reason for that primarily relates to these private acts. If you go and look up the private acts, they'll say in Knox County they don't do anything but what's allowed by statute. You go to the one in Blount County, they're allowed to do all these extra things. You're allowed to go to Loudoun County, the same deal. So if you want to find the limits of the general sessions jurisdiction in your county, you need to actually go look up the private act and see what they're allowed to do. The other thing about the private acts that are funny is it doesn't just give the jurisdiction, it'll talk about other things. Like if you go to Blount County, they do domestic stuff. Well, the clerk for Blount County General Sessions, when they're doing domestic stuff, is the clerk and master, which is weird, right? But then the clerk, when they're doing anything else, is General Sessions clerk. So that's strange. You can look that up, though. My talk, we've got at the Knoxville office for Legal Aid of East Tennessee, we've got a four-county service area. So I'm going to be talking primarily about our four counties, which are Knox County, Blount County, Sevier County, and Loudoun County, because those are the counties I actually know about. So what types of cases do general sessions courts have jurisdiction over? If you go to the statute, that 1615-101, you can find the cases that every single general sessions court in the state of Tennessee has jurisdiction over. And the first one is the most obvious, any kind of civil suit where there's less than $25,000 at issue. And that $25,000 is exclusive of court costs and attorney's fees or other discretionary costs. And there's some case law out there that says that this $25,000 limit is a jurisdictional limit on the court, meaning it's an issue of the court's power to do so. So even if both parties appear in front of the General Sessions Court and say, we know there's more, we know that you have a limit of $25,000, but could we agree that you could do more? Can you do more? And the answer is no. We don't have the power to do so. They can also do detainer proceedings, eviction proceedings, which Christina just talked about. One interesting thing about the detainer proceedings is that's unlimited value. So you could have a landlord that could be asking for $30,000 in General Sessions Court, and you can't object to that because they're allowed to do detainer proceedings with no limit. They're also allowed to do actions to recover personal property. Again, there's no limit in the value that you can do in Sessions Court for that. They're allowed to do writs of attachment, injunctions, and other extraordinary process. One interesting point that we've run into at Legal Aid is for Blount County, which is in our service area, both in the statute and in their private act, it says the General Sessions Court can do injunctions. But if you go to do an injunction in General Sessions Court, which we do all the time in our landlord tenant cases when these landlords lock people out and stuff, the General Sessions judges will say you don't have the authority to do an injunction in General Sessions Court, and so they won't let you do an injunction there. You have to go and do it in circuit court. But they are allowed to, even though they don't know it. They can also do direct contempts and indirect contempts. They can do interpleader. I don't know why you do interpleader in General Sessions Court, but you could. And they can execute on judgments. And then that's what every General Sessions Court can do. They're in our 4-county service area. Here's what they do. Knox County, they don't do anything other than what is listed there. And they also do criminal, but I'm only talking about civil. And then in Blount County, they're allowed to do divorces, order of protection, and probate. One thing that's interesting about domestic issues in Blount County is that they're allowed to do that by private act, but they're also allowed to do that by the statute. You know how when you're reading the statutes in Tennessee, this is another your Tennessee thing to me, they'll say, there's a section that says, for counties that have between 77,100 population and 77,200, you know, that's clearly a single county. I don't know why they don't just say Blount County. According to the census of 1980, so you have to look it up on the table and you find out that's Blount County. That in those counties, the General Sessions Court have original jurisdiction over domestic issues concurrent with circuit or chancery. So the authority for Blount County Court to do those domestic cases comes actually from the statute, and it actually makes a difference because when the General Sessions Court in Blount County is sitting doing domestic work, it's almost as if you're in circuit court. So all the rules that apply in circuit court apply there, even though it's the General Sessions Court. And just so, for instance, we're going to talk about this, but the rules of civil procedure don't really apply in circuit court, but they do in General Sessions Court. I'm sorry, but they do apply in General Sessions Court if you're in Blount County doing a domestic case, because they're hearing it as if they're a circuit court or a chancery court. Then you go down to Loudoun County. They're allowed to do divorces and order of protection, but only by the private act. And because of that, in Loudoun County, when you're doing a domestic case, they have all of the rules apply for General Sessions Court. So the rules of civil procedure don't apply, and the appeal process is different, even though it's the same kind of case in the same kind of court. So anyway, that's Tennessee. Loudoun County, they can do divorces, they can do orders of protection, they can do juvenile. In Sevier County, in addition to the other stuff, they can also do juvenile and probate. So to start a General Sessions lawsuit, you file a civil summons or a detainer warrant if it's an eviction proceedings. And just a little practice tip, the statute has a civil summons form if you look at it. If you go to the administrative office of the court's website, they'll have a summons form that you can pull down, but don't use those forms. And the reason for that is the courts typically, if you're going to file a case in General Sessions, they have a form that they want to use, and they get upset if you use like the AOC form. I know the first case I filed in Knox County, I pulled a form off the AOC website thinking that would be okay. I brought it to the General Sessions clerk, and she told me the judges won't hear a case that's filed on this form. They'll let you file it, but after you file it, we put it in a box, and it never goes anywhere. So do you want to file this? And I said no. So anyway, if you're going to Knox County, go pick up the form. Their local rules actually say that the summons form will be on their website. It's not. If you want it, you're going to have to actually go down to the clerk's office and pick up a copy, or you can call us, we can send you a copy. But you don't want your thing to end up in a box. Blount County also has their own form. So use the forms that they want you to use. So I'm going to tell you all about affidavit of indigency, which I know if you guys are filing not pro bono, you're probably not going to be able to use this, but let's assume you're going to do a lot of pro bono for legal aid and for yourself. So if you're going to do an affidavit of indigency under the code, and I have the code section here if you ever want to use one, under the code, any civil action may be commenced by an affidavit of indigency. And you can, if you're gonna file a case pro bono for legal aid or for anyone else that's indigent, go ahead and do that. Do it with an affidavit of indigency. One thing that I know when I talk to private attorneys, that aren't quite as familiar with filing these as we are, if you file an affidavit of indigency, that means the clerk of court is gonna defer the filing fee. It doesn't waive the filing fee. So someone's gonna have to pay them, it's gonna be taxed at the end. I've had people on the other side say, you know, we need this to be filed, why don't you file it on an affidavit of indigency, and then there won't be court costs, and that's not the case. And if you file something under an affidavit of indigency, you don't have a cost bond and you don't need surety. And you can find the forms for affidavit of indigency. Again, the clerk will have those. You can pull those, and they're not nearly as picky as with the civil summons. So you can use the AOC form, even though that's not the form that they might use. But the administrative office of the court has a form as well. If you go in Knox County, if you look under forms under circuit court, they have a form that you can use too. So just use one of those forms, have your client sign it. And if you're doing a case pro bono for us, I quoted Supreme Court Rule 29. Under Supreme Court Rule 29, basically it says if the person that you've got meets legal aid's guidelines for income and eligibility, which if we know something pro bono they would, then there's a presumption that they qualify for an affidavit of indigency.
May I ask?
Yeah.
If you file a pro bono case, use the affidavit of indigency, and you lose, is there a procedure for getting the court costs waived similar to what we just heard about in criminal cases?
I don't think so. No.
No?
And whenever I file a case for my clients, since I'm not making them write me a check for court costs up front, I make sure I tell them there's a risk here that, I'm thinking we're gonna win. Obviously, I wouldn't file this if I don't think I'm gonna win, but, there's always a possibility the judge doesn't see things my way, and if so, you might have to pay the court costs. So, and set up a payment plan. So that'd be nice. I think the court costs is an access to justice should be good. Okay, rules of evidence, they apply in general sessions court. What doesn't apply in general sessions court is the rules of civil procedure, and that's something a lot of folks don't know. That you can't quote the rules of civil procedure in general sessions court because they don't apply. There are 4 exceptions to when the rules of civil procedure do apply in general sessions court. The first one is the one I talked about a minute ago. General sessions is exercising concurrent jurisdiction with circuit or chancery courts. So that would be your Blount County doing the awards or doing the order of protection. The second time is after a general sessions case has been appealed to circuit court, which makes sense. If you appeal a case when you're in circuit court, of course the rules of civil procedure apply. Or if it is transferred to circuit court. Rule 69 as to execution of judgments, that applies. So after you've gotten a judgment in general sessions court or someone's gotten a judgment against your client in order to execute, you want to follow Rule 69 of the rules of civil procedure. And then Rule 60 is a little bit different. Rule 60 for alteration and correction of judgments. So the statute actually says Rule 60 applies in general sessions court. There's one huge difference though, and it's a very important difference. If you have a trial practice, under Rule 60.01, that's correcting clerical mistakes in a judgment. And both the rules of civil procedure and under the statute, there's no time limit for that. The court can at any time go and fix some sort of typo that they've made. Under 60.02 though, that's the one that people use the most. That's for, inadvertence, mistake, excusable neglect, fraud. Okay, under the rules of civil procedure, you've got a year to file those. Under the statute in general sessions court, if you want to file a Rule 60 motion, that's 10 days. If you don't file it within 10 days, then you can't file it anymore. That's a big difference. And then the other one is that the discovery rules under the rules of civil procedure, those apply in general sessions court, but only post-judgment. which is kind of weird. So after judgment, if you've got a judgment against someone, you can send out interrogatories or subpoenas or whatever in order to suss out their assets. Okay, so even though the rules of civil procedure for the most part don't apply in general sessions court, in sessions court they have, in the statute, there's corollaries to a lot of, some but not all of the rules. For the commencement of the action, you've got Rule 3 that talks about issuing the summons and all of that. That's almost identical in the statute and under Rule 3. One difference is if under Rule 3, if you send out a summons and it comes back unexecuted, that you've got 90 days to issue an alias summons. Otherwise, you lose your statute of limitations timeline. Under General Sessions Court, that's 9 months and not 90 days, so it's significantly longer. And this actually, if you do a lot of work in Sessions Court representing defendants, which I do, this actually comes up fairly frequently. You know, the client will come in my office and they'll say, they're suing me on a debt, and I haven't paid a thing on this debt in 10 years. Surely it's, barred by the statute of limitations. And then you go back to the clerk of court and you find out when they originally filed and how many aliases were issued and whether or not there was more than a 9-month gap between them. And you sometimes can get, even if the original action was filed within the statute of limitations, if they let the time lapse more than 9 months between filing alias summons, then you've got a statute of limitations defense. And this, if you do, like what Terry was talking about, if you do those kind of debt defense cases, when you think about the kind of folks that aren't able to pay their debts are also the kind of folks that move a lot. So they're the kind of people that you're going to have more than likely to file an alias summons against. Service of process, almost identical to Rule 4 under the statute, how you serve process. You can serve by certified mail in general sessions, almost nobody does, but you can. If you file on an affidavit of indigency, that service of process would be free. Not free, it'll be deferred like every other tax. Counterclaims, there are no counterclaims in general sessions court. What you need to do is, in the statute, they refer to it as a cross action. If you've got what would be a compulsory counterclaim in circuit court, what you need to do is go file a separate general sessions lawsuit and then alert the clerk and the court that they need to always be set together at the same time. Additional parties, I have it as a corollary to 13.8, and this is kind of like cross claims. If there's some other party that needs to be added to the lawsuit, there's a procedure under the statute where you can alert the defendant can alert the plaintiff and the clerk to the fact that there's another party that should be added, and then the plaintiff can get a reset of 30 days in order to get that other person served. This comes up all the time if you do represent debtors, because when you represent debtors, a lot of times the folks are divorced, and they'll say, why are they suing me? It's my husband that ran up the credit card debt. And so what you really want is for them to sue the husband or the, whoever the delinquent spouse was. One interesting thing, though, is you can do everything right and provide the plaintiff with notice of who the appropriate additional party are, but that doesn't require the plaintiff to actually sue them or bring them into the lawsuit. You can get subpoenas under general sessions court. That's a corollary under Rule 45. One thing that's really different about the statute versus Rule 45, under the statute, if you've got someone who doesn't comply with under the rules of civil procedure, if you have someone who doesn't comply with the statute, the circuit court or the case report, the remedy of the party that called that person, that subpoenaed them, is to do a contempt action, because the subpoena is basically a court order. There's a more summary process under the statute. If there's someone who without cause fails to comply with the subpoena, they shall be committed to jail without bail until willing to testify. So tell your clients to comply with subpoenas if they get a subpoena from the general sessions court. You can do non-suit. The non-suit rule is almost exactly like Rule 41 of the rules of civil procedure. They can non-suit at any time prior to the case being submitted to the court, and they can do that up to 3 times. And then we already talked about the motion to alter or amend the judgment, and that one incorporates Rule 60. Are there any questions? Okay.
Does state statute apply to general sessions?
Does what?
Saving statute, does that apply to general session?
Yeah, I think so. Right. Because isn't that why a lot of times people will file in sessions first just to save the statute, just to save the date? Saving statutes apply, right, Terry? Okay, so if you notice that there are a lot of sort of important rules of civil procedure that there's no corollary to in general sessions court, and the reason for that, I think, is that when you, and we're going to talk about this a little bit later, but when you appeal a case from general sessions to circuit court, you get an entirely new trial. And so I think the thought is that we're going to try and keep general sessions a little bit informal, because why go through a huge formal proceeding when if, you know, then if someone appeals, you just do the exact same thing again. But, so the procedures just in general are much more informal. Sometimes I'll have attorneys on the other side of me in my general sessions case, and they'll say, well, you never filed any answer. Well, you know what, I don't have to. You know, I can just show up for court, and that's in fact what most people do. There's no discovery except for post-judgment. You can get discovery if the court, by leave of the court, I've never had them do that for me. Their thought is just go up to circuit court if you want discovery. We're not going to do discovery down here. There's no real motion practice. You go up to circuit court, you know, people are filing motions for summary judgment and motions for judgment on pleadings. That doesn't happen in general sessions court. You go to trial and you try it. There's no need to attach the contract if you've got a contract case. That's like a little pet peeve of mine. There's no Rule 11. And the two times that bothers me is when I'm doing those sort of debt cases that Karen was talking about. A lot of times these folks they'll sue our client on credit card debt, and they won't have a copy of the card member agreement, they won't have any of the statements, they won't have anything at the time that they file except for that affidavit from, you know, the robo-signed affidavit from the credit buying, the debt buying company. And then if you say to them, I think I need to see some more documentation on this, they'll say, we'll order it. So in other words, they didn't have it in their office at the time that they filed suit against my client. I think that's kind of wrong that you're allowed to file a case in general sessions without actually being able to evaluate the merits of it independently. And the other thing where Rule 11 would have been helpful in general sessions court is that a lot of the attorneys that do a lot of work in general sessions court, they don't put their phone number or their full address. They'll just list their name and their bar number. For me as an attorney, that's not a big deal. I can just look them up in our directory. But for the typical client that gets that, there's no way to contact the opposing counsel prior to court about it. And you also have no, like we talked about, no counterclaims and no cross claims. The special judges, this is something that doesn't happen very often, but it happens every so often. You go into court and the judge is sick or something like that, so they've got a special judge. The special judge will be some sort of attorney that does a lot of work there that day. Under the rules, or under the statute, they're required to take every possible measure to find an actual judge before they can put an attorney on as a special judge. And here's the part that is different, and I think that clerks aren't very good at telling people about always, that the judges can only, those special judges that are not, you know, an actual general sessions judge, they can only hear a case if both parties agree. So if you walk in there and you see someone that is a licensed attorney in your area and he's got the robes on and you don't really like him or trust him, you can just say, I'm waiting for the regular judge to come back. And the other thing is that the special judge can only grant attorney's fees or other discretionary fees when the exact amount of the fees is set by statute or specified in the contract. Removal of general sessions cases to circuit court. You can potentially move any general sessions case to circuit court if you want to. You can either do it by agreement or by motion of the defendant. The standard for removal is that the defenses are going to be substantial and complex. And I have one that I removed to circuit court just the other day because the parties and I, the other side and I, we agreed on everything. We agreed completely on the facts. We just disagreed on what the statute of limitations was. So there's just no sense for us, and both of us knew. I knew that if I lost, I was going to appeal. He knew if he lost, he was going to appeal. So why do that twice? So we agreed to remove it up to sessions court. We just need to get an order from the court saying this is removed to circuit court, and then the clerk will be able to file one up there. if you want to appeal from a judgment, yes.
I'm sorry. Yeah. But one thing that comes up occasionally that has been a real nightmare for us is that in foreclosure cases, the client is being evicted after a foreclosure, which is generally when we get foreclosure cases. And they object to the way the foreclosure was done, there are defects in the foreclosure. You have got to raise that issue in sessions court, or it's res judicata. They can't bring another action to contest the foreclosure. And we run into sessions court judges in any county who don't think they can hear those cases, a contest of a foreclosure. But they've got to raise that issue, and that may be one that you want to remove as a report.
Right, yeah, and I had one with Terry where we were telling the judge, you have jurisdiction at this point, and he didn't really believe us. And he was like, why, I don't know what I'm doing on a foreclosure case. That was really crazy of this legislature to say I do. And I think that rule in foreclosure cases, that if you don't bring it up in general sessions, it's res judicata and circuit, is really weird, because we're going to talk about this in a second, but the laws, the cases say that once you get up to circuit from an appeal, that you're allowed to bring in new parties, you're allowed to bring in new causes of action. So I don't understand why you can't bring in a new defense, but the case law is against us on that. So if you ever represent folks in a foreclosure, and and there's a detainer action going, make sure you scream about the detainer in general sessions. So,
and I'm not sure that, I haven't thought about it much times, I'm not sure you can't raise it in circuit, because the cases have addressed when you're filing another suit, not appealing, because it's generally beyond the 10 days that they find out about this problem. They're bringing another second chance, because that's where they're hard.
and if you ever have that, the thing that's weird is that, so the foreclosure happens, there's a foreclosure sale, and so the person doing the detainer suit is often a third party that was unrelated to the foreclosure. So it's not obvious that you'd want to bring the foreclosure up in general sessions, because the party you're mad at is not there, but you still need to. So.
Could I ask you to speak up just a little bit?
Sure.
I'm having a hard time hearing back here.
Has that been a problem the whole time?
Start over, Jane.
Okay. Okay. There's a 10-day appeal period, and the thing that's hard about that 10-day appeal period is that that's jurisdictional. So if you don't file your appeal within 10 days, the case law says that the General Sessions Court loses jurisdiction over that case 10 days after the judgment goes down. And so that's why those Rule 60 motions have got to be filed within 10 days. If
You're recording it too, yeah.
okay, and then if you do, okay, so I should probably stop screaming if I'm
Is that good?
Can you guys hear me now?
Yes, that's better, thank you.
Better, but still not good, David?
You're okay.
I'm okay.
I'm sitting in the front row.
Yeah, it's jurisdictional, so 10 days after the General Sessions judge has issued judgment, you can't file a Rule 60 motion, you can't, there's cases that say that you can't get that motion set aside in there, and you can't appeal. So it's just over and done with after 10 days. So we regularly in our practice will come up with people. If you've been to General Sessions Court in Knox County, there's 200, 300, 400 cases set on a given day. Sometimes things happen. People aren't given notice of hearings. They were in court but didn't hear their name being called because they're out in the hallway. So what do you do if you actually had good cause for not knowing about the fact that judgment went down against you? So for instance, let's say I sue someone, and originally they get notice of the judgment, but then the case gets reset and they don't get notice of the reset. Well, under most of the case law, after that 10 days is over, even though you didn't have notice of the trial date, you're still stuck with the judgment, which seems extremely wrong, right? Well, there is one way around it, and that is you can't do a direct appeal because the time limit is gone. You can't go to the General Sessions Court and ask for relief because the time limit is over. But you can go to the Chancery Court and collaterally attack the General Sessions judgment on those grounds. Kind of obscure, but this is, we have a help desk we do in General Sessions every Wednesday, and we meet people all the time that say, well, I didn't have notice of that hearing. And most of the time when we investigate, it turns out they did have notice, or they should have had notice because they moved and didn't tell people or whatever. But I'm assuming at some point we're going to file one of these. So if you have a good reason for not knowing that the judgment went down against you, which would be a good reason for not filing the appeal within 10 days, you can go to Chancery Court and file a separate action saying, hey, Chancery Court, you need to overturn the General Session Court's judgment. There's 3 grounds for that. The first, you have to have, what they call a recognized ground, like fraud, accident, mistake. So kind of like the Rule 60 sort of grounds. Why is it that this judgment went down and you didn't know about it? There can't be any other remedy, right? Because this is Chancery Court, so that's something that's pretty much always true when you're asking for an extraordinary remedy. And the party seeking relief must not be at fault due to their own neglect or carelessness. That's where our legal aid clients that I've tried to do this for have usually fallen a little bit flat. If you don't keep the other side advised of your address and stuff. But if you have a client that comes into you and tells you that a General Sessions judgment went down against me and I didn't even know about it, and if you work with these folks, you hear that a lot, I would look in to see whether or not this would be some relief for them. And then the appeal from General Sessions is to Circuit Court within that 10-day period. The one exception, like we talked about, is Blount County in our area, in our Fort County area, is when Blount County General Sessions Court is doing domestic cases concurrent with the Circuit Court, then the appeal would be to the Court of Appeals. Okay, how do you file an appeal from General Sessions Court? You file a notice of appeal plus an appeals bond. But if you're doing this for legal aid or otherwise doing it for someone that's indigent and doing it on a pro bono basis, you want to file a notice of appeal and a pauper's oath in lieu of appeal bond. You can get all of these forms from the AOC website. If you pull down from the AOC website the pauper's oath in lieu of an appeal bond, it's a very short summary thing. Basically, your client is saying, I'm too poor, I can't do an appeal bond. The judges around here all demand that in addition to that, you also file a standard affidavit of indigency form, which if you've seen those, they're very detailed about the client's assets and income. And you can get all of that from the administrative office of the courts. Appeals are de novo, and that means you get a whole new trial in circuit court. After appeal, when you think about those General Sessions summons, they're really very informal. You get like one pleading is a single line. And according to the case law, and there's a lot of case law on this, the circuit court can't take any adverse action against the parties because the pleadings were so informal. And the parties may, but are not required to amend the pleadings. So if you want to make it more detailed for the circuit court, you can do that, but you don't have to. I have my irritating example, my pet peeve example. We do a lot of debt cases in General Sessions, and in General Sessions, you're not required to post a copy of the contract, even though a debt case is a contract case. And then if you appeal to circuit court, they still don't have to come up with the contract or attach it to the complaint. I think it's wrong. I think if you're suing someone on a breach of contract, you should be able to come up with a contract. And then if you do opt to amend the pleadings, it's a whole new trial, and you're not bound by what you argued below. So you can add new parties, you can add new causes of action, you can add new theories, you can add new counterclaims and new cross-claims. You're allowed to treat it just as a whole new lawsuit. And you're also not limited on appeal to the jurisdictional limits of the Sessions Court. So if you sue someone for $25,000 in Sessions Court, and then it ends up on appeal in circuit, you can say, I changed my mind, now I want $50,000. And there's nothing wrong with that. Okay, and then I have some tips, just if you're in the Fort County area that we have, how you would want to proceed. I've got a list of all the judges just to make it easier. The 5 judges in Knox County, there's 5 General Sessions courtrooms. 4 of the courtrooms are criminal, one is civil, and so they're just really a lot more familiar with the criminal law than the civil law. So if I'm in general sessions court and I'm arguing something that's not really simple or sort of routine, I always bring a copy of the law with me to show the judge. The sessions is on the old courthouse top floor. One thing in Knox County, the civil sessions only meets on Mondays, Tuesdays, and Wednesdays. If you have an emergency, you need to get some sort of emergency order from a general sessions judge on a Thursday or Friday, you're gonna have to go to the city-county building and try and find one in criminal sessions and get them to sign an order for you. And one weird thing about Knox County that I've never seen before, if you wanna file on an affidavit of indigency in Knox County general sessions, you have to bring the client to the judge, and the judge will swear them in and make them swear that what they said on their affidavit is true. I've never had any other court require that. And what that means is if you're gonna file a case in Knox County general sessions, you probably wanna do it on a Monday, Tuesday, or Wednesday morning, and get the clients there for that. They don't read through the docket. And then they take the uncontested cases first, and then the contested cases. If you've got a case in Knox County where there's just a bunch of witnesses, you've got people coming from out of state, you think it's gonna take a lot of the judge's time, you can get a special setting if you call the judicial secretary, and I've got her number there. She'll get you a special setting. And this is another weird Knox County thing. The Knox County people really don't like it when you have a litigants wear shorts. And so it doesn't matter if it's 100 degrees out, if it's awfully hot here in Tennessee, but it doesn't matter how hot it is out, if your client shows up in shorts, they are not going to be allowed in the courtroom, period. So if you're representing someone in sessions court, make sure they know, it doesn't matter if your shirt says terrible things, whatever, but don't wear shorts. And then, Blount County, there's, 4 general session judges, but one of them does nothing but juvenile. And then I've got their names and what floor they're on. And I've also got the schedule for the cases. One sort of oddity of Blount County General Sessions Court, and again, a weird Tennessee thing. There's not set court costs that are statewide. I don't understand that. So in Blount County, if you want to file anything after judgment goes down, they will charge you a $25 reopen fee every time you file something after judgment went down. So I had a case where there's kind of a mutual mistake and a default judgment went down. We went and got the judge to sign a motion setting aside default, and they won't file the order that I got signed until I file the $25 filing fee. So that's, if you're in Blount County, make sure, try to get stuff filed before the judgment goes down. And I talked about how they won't do injunctions. And then Sevier County, there's 2 judges. And one of the sort of weird things about Sevier County is that which courtroom you're being heard in will change depending on which week. You know, you never know exactly what courtroom you can be in, sometimes with the clerk. If you're doing civil sessions in Sevier County, one thing that's important to know is that every case is set first on a Thursday, and they will not hear a contested case on a Thursday. So if it's the first setting in a general sessions court in Sevier County, don't make all your witnesses come because they're not going to hear yet. They'll have to come back on some Monday. And then you think that the Monday docket would be really small since that's a contested docket, but it's not. It's often in like what's the name of that huge room up on the 3rd floor? You know?
They just call it the multi-purpose room.
Okay, yeah. They'll have this huge room that's just completely full of people for the contested docket, so you could be there for quite a while. And then if you're going to reset a case by agreement, you need to fax a copy of either a notice or a letter to the clerk to that effect. Okay, general sessions in Loudoun County, they just got a second one. I don't really know them very well yet. But most of the civil sessions, Judge Dale, who's great, and then he has court on Thursday mornings. Any questions? Yes.
Make my life easier. In Loudoun County, where they have current family law jurisdiction by private act, the circuit, chancery, the appeals are to the Court of Appeals, not to circuit.
Wait, there. So divorces go to?
Divorces go to the Court of Appeals in Loudoun, and the same is true of Roane County as well, that has divorce jurisdiction.
Now, that's because I just did an order of protection, and the appeal was to,
So the order of protections should come to us as well in the Court of Appeals.
oh, you're with the Court of Appeals?
Yeah, I'm the staff attorney for the Court of Appeals.
Oh, okay, so I have one in Loudoun County where, where the circuit court is hearing
They shouldn't be.
they shouldn't be.
I mean, I say it because I run into this problem like continuously.
Right.
Yeah,
Well,
my
I'm so
job.
glad you corrected me, because my outline is wrong, but no, never mind on that. I
Please
didn't know
show
that.
them the private act down there.
Okay.
If they're hearing appeals, they shouldn't be appealing.
Okay,
And that was Loudoun County?
that's
Loudoun
Loudoun
County,
County.
yes.
Yeah, well, because the person on the other side of my case was pro se, so she went to the clerk of court, and that's what they told her to do.
Well, I wish they wouldn't.
Okay. Okay.
We run into a lot of problems with trial court clerks telling them where to appeal.
Right.
And more often than not, they're not focusing on what type of case it is.
Okay,
And where the jurisdiction for the appeal should be going.
so is that true wherever General Sessions Court has?
No, it's gonna depend, like you said, on the private acts. But I mean, we hear divorces out of Blunt, Loudoun, Roane, General Sessions on a fairly regular basis when people appeal them correctly. If the circuit courts are hearing those appeals in those jurisdictions, they should appeal.
Okay. So let me ask you this, so everywhere throughout the state where General Sessions.
I can't speak to that. I'm
You
just
can't.
speaking to these particular ones I know about.
Okay, because I was just wondering if there's any courts that where the private act doesn't have.
I would just, my considered judgment would be consult the private act.
Yeah.
Every single time you're in Sessions Court in a family law case where the Sessions Court has family law jurisdiction by private act,
Right,
that's what I would do.
okay,
Because, I mean, and also, Loudoun also has probate,
right,
right? And those appeals come to the Court of Appeals as well.
okay. So what, and probate in Blount County, would that go to the court? Okay.
Well, again, I actually live in Loudoun County too, so I know more about
Okay.
Loudoun than probably you do.
Well, thank you for that, seriously, I didn't know that, now I know I need to get that kicked up to the court.
And if you have those cases that get appealed through the circuit erroneously, what you absolutely should be doing is asking them to transfer it to us. Sometimes the circuit courts enter orders dismissing the appeal for lack of jurisdiction, which you've now blown your appeal. You can't file a new notice beyond 30 days.
I'm representing the winning party though, so I'm going to probably file a motion to dismiss, but
But
yeah.
the appropriate remedy should be transfer of the appeal to the appropriate court.
Okay, any other questions or corrections, because I welcome that too. Yeah,
I was just wondering about Ray, they have a family court.
Again, I would consult the private eye.
and I've got, you can look at the private acts on the website. Great, that was